Hi, everyone. This is Preston Clark. Thanks for giving us a couple minutes to wait for folks to join. As I mentioned, this is an unprecedented, for all the reasons we understand, turnout for this event. So we wanted to give everyone as much time to join. My name is Preston Clark. I run EVERFI's corporate compliance division. And I'm here today with Samia Kermani here at Jackson Lewis office in New York City. So very appreciative to be partnering with Jackson Lewis on this. Obviously, this is top of mind for lots of HR and compliance leaders and executives and others who are trying to get their arms around the implications of both what we're seeing included in the budget that Cuomo just signed, as well as what's forthcoming in New York City, the implications of both, the overlap of both, and how organizations like the ones that you all represent can and should be thinking about addressing these in the months to come. And so we'll be covering a lot today. Just to get into the detail, so I'll be fielding questions as they come in. I know that many of you will probably have clarifying questions. So Samia will be delivering the bulk of the presentation today, but I'll be chiming in when folks want clarification on specific points that we're addressing. Just from a webinar basics perspective, would encourage those questions. I know that there's a lot of nuance and complexity to this. We may not be able to get to every question, but please, by all means, put those questions in. And if we don't get to address them during the webinar, happy to cover those later. We will be sending out the full deck. This is a great resource for you all to use to share externally or internally in terms of sort of a distillation of both the city and state mandates and all the implications. So that will be sent out in PDF format shortly after the webinar today. We're also recording this event, and so for those of you who want to rewatch it or want to share it internally, that will be coming into your inbox at the beginning of next week. And then at the close of this, obviously every organization, we sort of did I know when you all registered, you indicated your employee size, and we have lots of companies with over 10,000 employees, and we have lots of employees with under 500 employees. Obviously, this relates to every employer in New York State. So we expected that there would be a broad spectrum, but we also know that means that you have different ways to approach this and think about this, and different resources internally. We will be talking at the end and giving you an opportunity to engage with us, both EVERFI and Jackson Lewis, if there's an opportunity that we can be more supportive in helping you address these compliance mandates again in the months to come. So that's the basics. I assume most of you have been with GoToWebinar before. You understand where to submit questions on the right side, or chat. We'll be checking both. A quick, the 30 seconds on EVERFI, and then I'm going to pass this over to Samia. The reason why this event is important to us is that we're one of the largest compliance training companies in the world. We serve 1,500 corporations. We also serve almost 200 colleges and universities. So we do a lot of work in New York City and New York State, both with corporations and with higher ed institutions like NYU and Columbia and others. But from a global perspective, we work with companies both big and small that are looking to address in a centralized, scalable way, typically with a distributed workforce at scale, online training that is dynamic and gets what you need, whether it's meeting AB 1825 in California or Code of Conduct globally, GDPR. So that's why this event matters so much to us, because certainly we're watching closely to make sure that our customers, many of whom are on the webinar today, understand how we're going to help them meet this requirement in New York State, as we've done for them in California, Connecticut, and Maine in the past. With that, I'm going to pass this over to Samia, who will get us started into the substance of the event and tell us a little bit about Jackson Lewis.
Great. Thank you so much, Preston. Is that great? Thank you. So welcome to our discussion again, and thank you, EVERFI, for partnering us on this webinar and on so many other fronts. For those of you that don't know us, well, my name is Samia Kermani, and I'm co-chair of the firm's training practice group and a principal in the Boston office. And I spent a lot of time thinking about and conducting training, advising employers with respect to harassment situations, prevention policies, arbitration agreements. And we as a firm are a national workplace law firm, and we represent employers in all industries and conduct on the training front. We do live and in-person and live and remotely delivered training, and also do all other workplace law related matters and related practices on behalf of management. So whenever we do these webinars, we have to say this, which is this isn't legal advice regarding any specific situation. So our focus today is on New York. And the fact is that neither the law prohibiting sex harassment or the conduct that constitutes sex harassment has changed substantially in the last few decades. But what has changed is the sheer number of those who speak out about it. And what we're seeing is responses on various fronts to where we are in the #MeToo movement. And where we are is in a place of increased legislative activity, somewhat at the federal level, but really at the state and local level. And so our focus today is on New York, and specifically on the sex harassment related laws that were passed as part of the New York State budget, which was signed on April 12th, and the New York City proposed law, which we expect the mayor to sign any day now. So we're going to go into kind of give an overview of both of those mandates, and we do, as Preston said, invite questions. Please know that we are expecting guidance out of the Department of Labor, out of the city. We are expecting additional information. A lot of the questions you have, you're not alone with them, and we don't have a lot of answers. What you can expect from us at Jackson Lewis and Jackson Lewis in partnership with EVERFI is updates to this information as we get additional information. So with that, let's take a step. Before we go through the New York laws in detail, let's take a step back and talk about the fact that New York and New York City are a representative of what's happening in legislatures across the country. Not unlike what we saw with sick leave laws sweeping the nation, or parental leave laws popping up in various states, or more robust equal pay laws being enacted in states around the country. What we're generally seeing, and what we should expect more of, is that states are saying, okay, we're going to pass our own more rigorous employee protectionist legislation, right? For example, Washington State recently passed a law aimed to combat sex harassment, and it focused on prohibiting confidentiality provisions and confidential dispute resolution agreements as they relate to claims of sex harassment. In Washington State and in many, many other states, there are mandatory training laws in the works. And why this is relevant to a conversation about New York is that it's not just going to be an issue in New York. Multi-state employers in other states also have to pay attention to this issue as you in your organizations are trying to figure out how to comply with New York. We kind of have to keep our eye on the ball in other states as well to come up with a program that it works for you. Lots of questions that we've been getting on this front is, okay, wait a second, we are already compliant with AB 1825 in California. Shouldn't that be sufficient? And the fact is, there are a couple of things I want to say about that. Number one, the California current mandate applies to employers with 50 or more employees. The mandates that we're going to be talking about today with respect to New York apply to everybody. Now, content-wise, there are probably similarities, but they're not exactly the same. The other thing about California, which is critical, is that as the law exists today, it applies only to supervisors. You only have to train supervisors if that law applies to you today. What the New York law says and the New York City laws that we're going to talk about today say they apply to all employees. So California has a few bills that are proposed now, which are going to change so that they too are going to require, which are going to change the current requirements so that they too require training of all employees, not just supervisory employees. So there are what we're calling these #MeToo response laws that are popping up, and they cover many of the things that we're going to talk about today, like limits on the use of arbitration agreements, limits on the use of confidentiality agreements for sex harassment claims. And legislators, they're a lot like lawyers. They never like recreating the wheel. So what they do is that they look to see what each other is doing, and then they tweak it a little to make it unique, which creates a patchwork of obligations, which can be particularly problematic for multi-state employers who strive for consistency across their organizations. And where we are in time right now is that just like what happened in New York, these laws are likely to pass in some way, shape, or form and relatively quickly, because at this time, people are paying attention and watching this issue. So it's something that we have to keep our eye on. And you're saying to yourselves, I know, that's why we're here watching this webinar. Okay, so on April 12th, 2018, Governor Cuomo signed the state's budget, and Part KK took effect with various deadlines for its various sex harassment related provisions. I'm going to first walk you through sort of those dates and then dive into what the mandates actually are. So with immediate effect, non-employees, including contractors, subcontractors, vendors, consultants, other people providing services pursuant to a contract now are protected again under the New York State's human rights law, even though they're not employees, with respect to harassment. So even though what we've done historically is gone through giant steps to ensure that they're actually not treated like employees, now what this law is saying is that if for purposes of sex harassment claims, they will be. So we'll go into that in a little more detail. July 11th, the law's prohibitions on the use of non-disclosure provisions in settlements or arbitration agreements relating to sex harassment claims kick in. October 9th is the deadline by which model sex harassment policy and guidance has to be published by the Department of Labor, the New York Department of Labor, in consultation with the Division of Human Rights. Based on the model documents, employers are required to distribute the model policy or one similar to it to all employees. Also on the same date, they are to the DOL and the Division of Human Rights, they're supposed to publish a model training for all employees in the state, which is consistent with, and employers are to adopt those trainings and provide them to all of their employees, or at least those or something better, right? And finally, by January 1st, state contract bids have to contain certain affirmations regarding compliance with these policy and training mandates. So let's break this down. Let's talk about the expanded coverage to third parties for a minute. So as I said, the effective date is immediate. So non-employees are now covered. And what it says specifically is that the employer can be held liable to a non-employee with respect to sex harassment. So in the past, the law only applied to employees, and now it says the employer now can be held liable to a non-employee who is a contractor, subcontractor, vendor, consultant, or other person providing services under a contract, or somebody who's an employee of that third party. with respect to sex harassment, but it's qualified. An employer can be held liable to a non-employee for sex harassment perpetrated against that non-employee when the employer, its agents or supervisors knew or should have known that such non-employee was subjected to the sexual harassment and that the employer didn't do anything about it. So this should mean that once we as employers are on notice of an issue involving the harassment of a third party associated with our business, we actually have a window within which we can do something about it. That means that once we're on notice, our duty to act has been triggered and we have a window within which we can take prompt action and hopefully avoid liability. And generally, this is the same standard that we're familiar with. This is the standard that generally applies anyway. So what this means and what this should translate to for us is that our supervisors, i.e. those generally who have the authority to make, influence, or recommend employment-related decisions, they need to understand that they are not to subject, that no one is to subject third parties associated with the business to harassment, and they have to ensure that non-employees are not being harassed on their watch. So this is a training issue for supervisors and can be incorporated into your training programs. Okay. So that's the expanded coverage provision of the New York State law. Let's talk about what the New York State law says with respect to settlement agreements of sexual harassment claims and non-disclosure agreements. So what this provision says, first of all, the effective date is July 11th, right? 90 days from when the law was signed. And what it says is so we can no longer include a confidentiality provision in a settlement agreement for a sex harassment claim unless the complainant wants it to be confidential, unless it's the complainant's preference. And so typically when we enter into a settlement agreement, part of the settlement agreement often involves a confidentiality provision. And what this law says is that you can no longer just automatically do that. And you can no longer just assume that if the complainant agrees that that's enough for purposes of the settlement agreement, but rather the law goes further and says it has to be the complainant's preference. And here's how we're going to make sure, or how you employers need to make sure that it is actually the complainant's preference. What they did was they looked to the old standard from the Older Workers Benefit Protection Act, which long ago told us that if you're going to require somebody to get a release for a federal age discrimination claim, you should give them, among other things, 21 days to consider whether to sign that release. And then once they've signed it, they should be given 7 days to change their mind. Sounds familiar, right? This is the standard that the New York State adopted for confidentiality provisions in settlement agreements of sex harassment claims. They have to be the employee's choice. So if an employee is going to include, or if an employer is going to include a confidentiality provision in a settlement agreement of a sexual harassment claim, then the employee has to get 21 days to consider whether to sign it, and then once it's signed, has 7 days to revoke that signature. So this means that we have to change the way we draft and we engage in settlement agreement negotiation. We also have to think about, in some circumstances, whether we have to give that 21-day consideration and 7-day revocation when we're entering into a separation agreement with an employee who may have raised sex harassment claims in the past. So that is kind of a very specific new requirement. Now, the text of the law leaves open a question. It leaves open it's not clear from the language alone whether the law requires that if, at the end of the day, the confidentiality provision is the complainant's preference and there is a 21-day consideration period and a 7-day revocation period, it's unclear from the language of the law whether the confidentiality obligation also has to apply to the employer. So we'll have to see how this plays out, and we have to think about that, but it's something to think about when we are entering into settlement agreements with employees who have raised harassment claims. Okay. So next up is the prohibition on arbitration agreements. So this part of the law is effective July 11th, 2018. And what it says is that a clause in any contract that requires arbitration of a sex harassment claim is now prohibited and would be considered, quote, null and void, unquote. So the New York law as drafted also says, except where inconsistent with federal law, no written contract entered into after the effective date, which is July 11th, shall contain a provision in a contract that requires arbitration of sex harassment claim. Now, the law also says that the inclusion of this prohibited arbitration clause in a contract doesn't impair the enforceability of any other clauses in that contract, but it says that arbitration, mandatory arbitration of sex harassment claim provisions are null and void and are not to be entered into. New ones are not to be entered into after July. This provision does not apply to collective bargaining agreements. So it seems that arbitration agreements that require sex harassment claims to be resolved in arbitration rather than litigation are null and void, and that it would be against this law to enter into a new one. But this is a state law that squarely impacts arbitration agreements. Back in 2011, in a case called Concepcion, the U.S. Supreme Court told us that you cannot have state laws that treat arbitration agreements differently than any other contract. So what the Federal Arbitration Act says is that arbitration agreements should be on equal footing with any other contract. So if you have a state law that puts a condition on arbitration agreements, but it's not a limitation that's imposed on any other contract, that really should be preempted by the FAA. So we think that there is a good argument that this law and others like it should be preempted by the Federal Arbitration Act. But the existence of this preemption argument means that we may have to litigate this issue. So there's lots to think about here with respect to what do we do with existing arbitration agreements that we have with employees? Do we carve out sex harassment claims? Do we leave them in on the theory that we think they're preempted? Do we carve them out of new agreements going forward? So there's a lot to think about with respect to this issue. Okay. Next up, model policy requirements. Okay, so by October 9th, the state's Department of Labor is supposed to consult with the Division of Human Rights to create and publish model sex harassment prevention guidance and a policy. And every employer is to adopt exactly that policy or one that's at least as good, and provide it to all employees in writing. The DOL and the HR division are supposed to post this model publicly, publish it on the website by October 9th. Now, what's the policy supposed to include? that which many employers already have in their policy. An explanation of sex harassment with examples, federal and state statutory provisions and remedies, a procedure for the timely and confidential investigation of complaints. And interestingly, this is what the EEOC recommended when it published its study back in 2016 on sex harassment, saying every employer should have one of these policies, right? And many employers do, right? There are other requirements for this policy. We don't have to go through all of them, but I think what's important is that they want it to be widely disseminated to all employees, the fact that there is a policy and this is what you do if you encounter harassment in the workplace. So the Department of Labor and the Division of Human Rights are going to be consulting a lot now. In addition to consulting about a model policy, they're also to consult with each other about a model training program and have it up and published by October 9th. And this model training program is supposed to be interactive. And like the model policy, employers can use that which they publish or adopt their own as long as it's just as good as the model. It has to be administered to all employees. And here's the kicker. All employees every year, annually. Now, this is a big deal. Many employers train supervisors, and they may do a periodic every few years policy refresher for non-supervisor employees. Now, every employee has to be trained. Now, so far, we don't have information out of the New York State DOL or the Human Rights Division about how long this training is going to be. It may borrow from the California and Connecticut supervisory standards and say it should be 2 hours. I can't imagine that they are going to require 2-hour training for every single employee in the state of New York, but we don't have an answer to that question. And I know all of you have that question in the backs of your minds. What does training all of our employees mean? We have employees that work night shifts, day shifts. They work in various locations. This is logistically difficult. Tell us, how do we do this? And if the Department of Labor publishes a web-based training or a training video, how do we get it to all of our far-flung employees, many of whom don't have, may not have internet access through us? So how do we do this, right? So this is something that we're awaiting guidance about, right? So not surprisingly, the training requirements for the model training are nearly identical to the policy requirements for the model policy. You have to include an explanation of sexual harassment and provide examples of unlawful sexual harassment. Now, New York says it has to be interactive, but it hasn't given us detail about what interactive means yet. Right? There's also a requirement that we go through the rights of redress, all available forums for adjudicating sex harassment complaints administratively and judicially, and that we also address conduct by supervisors, and that we talk about the fact that retaliation is against the law. So importantly, the DOL commissioner, it says may promulgate regulations, and we hope they will promulgate regulations to answer questions like, how long do these sessions need to be? What's the scope of the training program for all of the employees versus the supervisory employees? What does interactive mean? What does annual mean? If I trained everybody 2 weeks ago, does this mean I have to go and train everybody again in October? What does it mean that October 9th is the deadline? The deadline, so the effective date of the model policy and model training programs of this law, what it says is that the effective date of these provisions is October 9th. That means that by October 9th, the Department of Labor is supposed to post the model policy and the model training documents, model training forms on their website. But it's not clear that that's the date by which all employers are also supposed to do that. So we're hopeful that the regulations, and we anticipate that the regulations will address questions like this, because if you are an employer asking yourselves questions like this, you should know that you are not alone, and which is why I think there are over almost 1,000 people registered for this program, right? Okay, so finally, if the law says that bids that are made to a state or state agency bids that are made to the state or an agency where competitive bidding is required by statute, rule, or regulation, you have to include certification. It's essentially a certification that the bidder implemented the policy addressing sex harassment in the workplace, and that it provides annual training consistent with the law to all employees under the pains and penalties of perjury. And the statement can be submitted electronically. The consequences are the bid won't be considered for the award, or they won't get the award. And if a bidder can't make that certification, you have to provide reasons why. What I would say about this provision is that when oftentimes when we are entering into contracts like this, if we have a policy and we've issued the training requirements, we'll make that certification in good faith, but we have to think about, does our policy really comply? Have we really trained everybody that we're supposed to? So that's something to think about for organizations that enter into bids for state contracts. Okay, so I'm going to pass it over to Preston.
Great, thanks, Samia. We're going to take a 2 minutes to do a poll. We have 3 polls total, so this is sort of intermission. It's going to last all of 90 seconds, and then we'll get back to Samia. First, for those of you who joined late, we will be sending all of the slides that Samia is going through in a PDF format immediately following the webinar, but we'll also be sending a recording early next week. There's a lot of questions coming in. Some of them are being asked and answered in the context of Samia's presentation. So I think those, for some of them, relate to the correlation or the relationship between New York State, the timing, so April versus October. So all of these things will hopefully, most of the questions will get addressed through the back half of the webinar. So please continue to ask the questions. If we don't get to them live, I promise that we will do this in just a minute. We'll try to get to as many of them as we can, but we'll certainly get to them afterwards if we cannot. For many of you, the questions are coming in. What precipitated the Me Too legislation, of course, was the Me Too movement. And so a lot of organizations, publicly or otherwise, made the decision to do annual training for all employees and going above and beyond certainly what California was doing. And so this question is really to gauge for the hundreds of folks who are on the webinar today, to gauge if you all are doing something already expansively for all employees, if you were already ahead of this, just to get a sense of how organizations have been thinking about addressing sexual harassment training. So we're gonna, and I apologize for not giving context, we're gonna actually do this poll through GoToWebinar, so something's going to appear on your screen in just a minute. So for those of you who already submitted those via the question box, I'm going to ask you to do that again. So our folks, our GoToWebinar folks, are going to put that on the screen now. So do you currently train all of your New York State employees? Yes, no, not sure. We'll leave this up for about 30 seconds and then we'll close it. I want to get back to Samia, but we'll show the results, and we'd love to just get a sampling from across the group of how you all have been thinking about this, because certainly I know for many organizations you've been preparing to take a more expansive approach to sexual harassment training already, long before these bills go into effect. We'll leave it open for just 10 more seconds and then we will close it out. Okay, great. We can go ahead and close that and we'll show the results now. Okay, so 42%, yeah, so that's tremendous. So for many of you, you were already moving in this direction, and that's great, and 50% no. So huge kudos to many of you who've already have been ahead of this. That's great. And with that, Samia, I'll pass it back to you.
Can you unmute me? Great, thank you, Preston. And that's, it'll be much easier for all of you to, those of you who have already been training everybody, it'll be easier for you to implement these requirements on that front. So let's talk about the city. So New York City, not to be outdone by the state, passed the New York City law passed the New York City's council the day before the New York State law was signed. And this New York City law is expected to be signed by Mayor de Blasio any day now, really. And generally, it's similar to the state mandate, but I think it's a little more prescriptive. It provides a little more detail. So let's go through what it says. So the New York Commission on Human Rights is supposed to make information available on its website regarding sex harassment within 90 days of the law's passage. And the information the commission is to post on its site is going to include, or is supposed to include, an explanation that sex harassment is a form of discrimination under local law, its specific descriptions, the fact that it's unlawful under local, state, and federal law, a description of the commission's complaint process and how to contact the commission, a list of alternate and additional government agencies for filing complaints, an explanation that retaliation is against the law, and it is to include information about bystander intervention education and the importance of taking action to prevent workplace harassment. So one of the things, and I'm sure those of you who have been thinking about this over the last few years, really, there's been a real increased focus on including in training programs bystander intervention strategies. And that's something that we've been including in our training programs about. We want to, of course, impart the message that employers should let their employees know how to report an issue after it occurs. Here's our reporting procedure. We're going to do an investigation and take action to stop it. All that's great. And and the EEOC said this in its 2016 study as well. And what they said, and what the New York City law is saying is that, look, it's really important to empower employees with information about how they can respond in that moment, right there and then. Not just about reporting it to HR after the fact, but things they can do, and they want that information posted on the commission's website. And they also want an interactive tool describing each step of the commission's complaint process. And they want the commission to make that available, that interactive tool. That's technologically daunting. But, and then employers are supposed to post a poster in English and Spanish, and the commission is supposed to make that poster available. It even has font size and style requirements. So you're going to have to post, where you post other things, you're going to have to post this. The commission is also supposed to prepare an information sheet, and that information sheet employers are supposed to distribute to employees at hire. The commission is also supposed to have issued rules within 120 days of the law taking effect. So the commission's going to be very busy in the next several months. Okay, the other thing I wanted to say about the New York City law is that there is a training requirement. Now, the New York state law applies to all employees. So all employees under the state law have to be trained. Employers with 15 or more employees in New York City are to provide interactive training to employees within the city of New York. So let me say that again. Employers with 15 or more employees have to train and provide interactive training to employees employed within the city of New York. And what's not clear from this language is whether that applies to employers who have more than 15 employees anywhere and 1 employee in New York, or 15 employees in the city of New York. Also, the annual interactive training is required, just like under the New York state law. But as I said, the New York City law is a little more detailed. It says interactive training just means that it has to be participatory. It can be online or other participatory forums as determined by the commission. So there has to be a way of interaction. And so again, just like with the New York state law, we don't have information, at least not yet, about how long these sessions have to be. Okay, so what the law says is that you have to train full and part-time employees who work more than 90 hours in a calendar year within 90 days of hire. And you have to keep records, including employee acknowledgments. So this means when you are doing New York City training, you have to have employees sign off on the fact that they took that training. Now, that sign off can be a paper, ink, wet signature, or it can be an electronic signature, but you have to have them sign it, and then you've got to maintain those records and track those records for 3 years. So this is both a record-keeping requirement and a training requirement, right? Okay. So the city's requirements are very similar to the state's requirements. Explanation of sex harassment as a form of unlawful discrimination under the city's law, under state law, under federal law. What is it? Include examples. Include your internal complaint process, the complaint process with the Commission, with the Division of Human Rights, with the EEOC, with contact information. That's new and different from what was required, what's required under the state law. Incidentally, many states already include such provisions, including Massachusetts, right, for employers with 20 or more employees. Lots of states have policy requirements, and so now the city's law is saying you have to include the contact information for the agencies. You also have to make clear that there's a prohibition on retaliation. That's the same under the state law. And you have to include information concerning bystander intervention, including resources that explain how to engage in bystander intervention. Now, this is not in the New York state law. The text of the law, it may come out in the regulations or in guidance, but it is in the EEOC's recommendations in its 2016 study. So, include specific responsibilities for managers in this. Now, if an employee, what the city law says is that if an employee got trained at another employer, you don't have to give them additional training until the next time you do this training, as long as it meets the minimum requirements of the city's laws. So the training that they may have received from someplace else. Same with another state's training. Another state's training is okay if it meets New York City's minimum standards. Okay, so the Commission on Human Rights is responsible for creating an online interactive module and posting it on its website. The problem is that that may not be tailored, is not going to be tailored to employers' particular policies. And it takes a lot to develop an online training program. So I think the commission has a lot of work to do to create an interactive, off-the-shelf online training module that every single employer from the bodega to Wall Street can pluck off the website and somehow administer to all of its employees. So, we don't know if it will have the ability to track and certify attendance. We don't know if it will have what interaction will mean, how questions would be answered, and whether it would meet the requirements of the state training either. One would hope that there would be discussion so that the state's program and the city's program are the same, but I think that's a wait and see. So expanded coverage, the New York City law expands coverage of its human rights law when it comes to gender-based harassment to include employers with fewer than 4 employees. Independent contractors are counted as employees for these purposes, and the statute of limitations for filing gender-based harassment claims under the city's human rights law has gone up to 3 years from 1. So it's easier to sue, right? So this is a lot to take in. These are a lot of changes that are coming down the pike. So let's hear from you all.
Yeah, so we're going to post this question, so don't respond to the poll just yet. Similar to last time, we're going to post this up in an interactive format in just a second. I had the privilege of spending my morning with Jonathan Bing here in Jackson Lewis's New York office, and he heads up the government relations division for Jackson Lewis, and we were talking about New York, and one of the realities is that legislation like this gets passed without a full understanding of the burden of what it means. And as Samia is going through it, I'm sure many of you have your blood pressure going through the roof, thinking about not just the substance of the content, but the mechanics of administration, how you're going to do it. If this means you're going to have to do global training now, if you have distributed workforce, if some people have computers or some people don't, if the 90-day is a huge one where you're saying, okay, it used to be that our harassment training was event driven, like once a year, every June, every January. But now knowing that within 90 days, and if you're an organization that hires at any considerable interval, that means that this is not something where you can just do, once a year. It's something that's going to have to be a permanent workflow. And so there are a lot of implications to that. I want to hear from you, so we're going to post a poll now. As you're hearing through this, I know that you're still processing it. I know that there's still more questions, and we're going to follow up with you all, and we'll have answers to come. Some of the answers we're ready to give you now, and so those will be sent out. They relate to pieces of the legislation that are clearly understood. Others of them, as Samia has indicated, we don't know yet. So there's some wait and see, but you have our commitment, both from EVERFI and Jackson Lewis, that will make you aware in an easy to consume way as more clarification comes out. So let's go ahead and run this poll now. Would love to understand your perspective on this. And it's just, this is sort of let's commiserate together a bit about the complexity of this. Training administration, is that a primary concern for you? Maybe you have a distributed workforce and you're thinking, gosh, I have 4 locations in the state, or now we're going to have to do this nationwide, and I have 18 locations. And oh wait, what about our French office? What are we going to do for them? Content consistency across multiple states. You can select more than one on here. How you're going to reconcile what may be coming from New York, what you're already doing in California, because I assume the goal is to not have 18 different versions of harassment training. The notion of training fatigue, as Samia led off with, it's one thing to do something every other year. When you start talking about annual training, the notion of, well, gosh, it's okay to do this once, but when suddenly now, you know, Bob in finance is going to be watching this thing for 4 years straight, how you think about updating and maintaining content, not just from a compliance perspective, but from an instructional design and user experience perspective. Technology constraints. If you're going to do in-person with Jackson Lewis, that's great, but maybe given your workforce, maybe it's manufacturing, maybe it's retail, maybe these people, maybe online is the way to go, but there's additional constraints in terms of how you're going to reach your audience. So if that's something you're struggling with, would love to get a sense of that. And then independent contractors or others, temporary hires, folks who normally, let me just sort of recharacterize that question. It's really about the folks who you've normally not trained at all in the past, if that's sort of what's getting your blood pressure up the most, as you think that that's a new population that maybe they're not in your learning management system, maybe it's just not something that you've had to workflow before. We'll go ahead and post the results of this now. Okay, so 55%, and this was multiple answers, so you could fill in more than one. So 55%. The two biggest ones are training administration and consistency across states. So I know that there's a lot of large organizations on the webinar today, and so presumably for you all that have distributed workforces across the country. I had some great meetings in the city yesterday here, talking with chief compliance officers and CHROs about this in particular. So we're sensitive to this pain, and I think as we get more information from the state and the city about what needs to be included, whether it's bystander intervention or whatnot, we will be working with you to ensure that you don't have to have numerous versions. That said, we don't know, as Samia said earlier, if there's going to be a time constraint like there is in California, or a time requirement.
Not yet.
Right. So that would be a potential inconsistency that we're going to have to work through, but more information to come. So we're going to wrap here in just a minute, so we can go to the last set of slides, and I'll close us out. So let's see if we can go to the next slide. We certainly we want to just take a couple minutes to wrap this up. I know we're getting close to the top of the hour, so I'll let Samia close us out with a couple takeaways, and then I have one more poll that I want to run before we end this. So thanks for sitting tight with us as we close this out. Samia.
Great. So I think that just looking at this from 10,000 feet is really important. The fact is, many employers already conduct training programs, whether they're in person for some segment of their population, whether they're online, exclusively online, whether you train your internal folks, you send them to train the trainer programs, and you train them to deliver your training, whether you train to your specific policies, whether you include it as part of an overall general code of conduct. There are lots of ways to do this, and to look at this from a 10,000 feet perspective is to understand that where we are in time is that this is the New York State's requirement. This requirement is some version of it is likely to be adopted everywhere. So this is kind of now an absolute mandate, and I think employers are going to have to be training all of their employees in some way, shape, or form, and it can be done. Content-wise, I think the only real new thing that's come out of, and it's not even new. Lots of employers already do some version of bystander intervention training, but this is, to my knowledge, the first time a bystander intervention training has been required in a law. It's not currently required under California or Connecticut or Maine, for example. And what it essentially means is to include information for employees so that they understand what they can do in that moment. And the fact that it is everybody's responsibility as part of our work environment to uphold the organization's standards. And so, to include that, something about that in our training programs. So Stay tuned on the New York front. Stay tuned for model policies, model training programs. Stay tuned really for those regulations, because I think those will help us a lot with the outstanding questions. For those employers who have existing arbitration agreements, dust them off and see what they say with respect to sexual harassment claims and their coverage. Most likely, sex harassment claims are covered within your arbitration agreement. Now is the time to be deliberate about the various options for dealing with that issue now. And finally, review your confidentiality provisions in settlement agreements and even in some separation agreements. And this is kind of, these subjects are what are being considered in proposed laws everywhere. So with that, I'll pass it back to you, Preston. Thank you.
Great, Samia, thank you so much. This has been, I know this is a lot of information. We will be sending out the slides. I know for many of you, and I've spoken to a lot of you already on this, and certainly Jackson Lewis's phone is ringing off the hook the way ours is in terms of helping organizations get their arms around this. I think for many of you, you may have big legal departments, big compliance departments, big HR departments, and you feel really strongly that with this information, you can internalize it and build the resources and your approach to meeting the requirements as they come forth, and that there's nothing we can do for you, and that's great. We'll continue to give clarity into what is required, and we hope that that's helpful for those of you who would like some help, either just us giving you some guidance or recommendations, either from Jackson Lewis or EVERFI. We're happy to do that. I know that this is a lot to take in, and we certainly want to be resources for all of you. So the last poll question, would love for your participation. If there's anything, if we can put that poll up on the screen now, if there's anything we can do either in the capacity of you know, everything from an executive summary for your board, because I know many of you, either your C-suite or your board is going to ask for what the heck does this mean? What should we be doing? What do we have to do in New York? What do we have to do beyond? And so if you're interested in some summary information on that to make that part of your job easier, if you'd like sexual harassment policy review support from Jackson Lewis, and certainly we're a global training organization. We do everything from sexual harassment to GDPR, do multiple languages, do it at scale. We train millions of people a year. We power some of the largest tech companies and finance organizations in the world. So happy to have those conversations if it makes sense. But Jackson Lewis also does in-person training. They're, as far as I know, one of the largest providers of in-person training in the country. So this is stuff that they do very well. And Samia is obviously exceptional at leading that practice group for Jackson Lewis. So feel free to engage in this. Again, a recording will be going out. The slides will go out in just a minute. We received about 150 questions, Samia, during the webinar today. So I promise if we didn't get to your question that we will follow up in the next few days. Let Samia and I have some time to go through those. We have day jobs too, but I promise we'll get through them as quickly as we can. And then let's just go to the last slide. Let's just jump to that with our contact information. Preston at everfi.com, Samia.Kermani at jacksonlewis.com. Feel free to reach out to us individually, connect with us on LinkedIn. Again, this is not done. There's more information to come, and so we know that as you all are preparing to meet these mandates, both at the city and state level, that you're going to have more questions, and so we encourage you to use us as resources, and we'd love to help any way we can. Samia, any closing words?
Yeah, I think you said it all. Thank you so much. Thank you for participating, and thank you for co-hosting this webinar with us.
Awesome. Thank you. Thank you. Thanks, everyone, for joining, and again, a recording will go out at the beginning of next week. Thanks.